Thanks a lot for the invitation. Thanks for the opportunity to talk today. I'm talking about research I did together with the people here listed on that first slide with Miriam Hildebrand, Jakob Slosser, Ronan Kennedy, Elizabeth Staudecker, and Jamie Baker. And together we were involved in something that some of you might be familiar with. It's the AI for People expert group at Atomium, the European Institute for Science, Media and Democracy. And 2 years ago, Atomium started to bring together experts on AI to think about appropriate ethical frameworks for good AI society. And the work that we did there had 3 iterations by now. The first resulted under the chairmanship of Luciano Floridi in a sort of broad framework, the AI for People's Ethical Framework for a Good AI Society. That was a relatively abstract top-level document. In the second iteration, it chaired by Ugo Pagallo, it drilled down a little bit on these ideas from the top-level document and some further substance to them, further details to them. And there was already, I think, some impact of that work in the 2 reports that were presented in Brussels. There was also personal overlap between that group and the EU high-level expert group on AI. So some of these recommendations that we came up with already found their way, I think, into the new proposed AI regulation of which we heard this morning. And one of the things we realized after finishing with these 2 iterations was that while there are definitely some principles on AI that are cross-sectorial, quite a lot of the hard ethical questions will come in specific fields of application that are sector-specific. And if you heard this morning, this is also reflected, I think, in the new proposed AI regulation, which defers certain details and implementation very much to sectoral agencies, legal frameworks, and supervisory bodies. So in the third iteration, we developed sector-specific rules, and in particular, we formed 7 subgroups to look at particularly problematic sectors that included media, that included banking and finance, which we heard earlier today. And I, in particular, was chairing the specific expert group on the application of AI in the legal sector. So one thing I have to say in advance is we, partly due to COVID disruptions, we were not able to deliver our report as early as we had hoped. So law, together with 3 other sectoral reports, still need to get formally presented. And that means what you get today from me is only a little bit of a spoiler, only those principles that we already discussed in public, that we presented at an intermediary meeting in December. And hopefully by October, the full document will be presented in Brussels, hopefully with some attendance from the European Commission. What can we say about law? The Law Society of England and Wales has also set up its own expert group on the impact of AI on the justice system, trying to see what role it as a society should play, and carried out one very interesting study that tried to quantify the impact that these technologies already now had on the UK legal services sector. Now, that figure has to be taken with a little bit of caution and a grain of salt. If you look at the years that are covered by that study, we have 2008 here, the global financial crisis. This study was made in 2018. That was pre-COVID, so the figures that were anticipated or forecast for 2020 might obviously not be quite accurate. And that is always the danger here with these complex social prognosis and forecasting. But it seems at least to be the case that AI is already now affecting the legal service sector, that in particular fewer jobs are created than we should have otherwise expected. So that I think gives specific urgency to looking at law as a field of application. Yeah, I said 4 of the 7 reports are already published here. You can find them at that URL. And what we came up with were 20 principles that we think should inform ethically sound deployment of AI in the justice sector. The standard disclaimer at this point, we are very empathetic about the fact that ethics is not a replacement for regulation, and that ethics only starts where compliance has been achieved. That includes data protection law, for instance, but it also includes such laws in the UK, for instance, as the public sector equality duty under the Equality Act. So biased AI, for instance, is not primarily an ethical problem, it's a legal problem. Biased AI, especially is deployed by the public sector, is simply illegal because it violates the equality duty under the Equality Act. And so we are not talking about compliance. We assume compliance has been achieved. And then we ask, what can we do above and beyond this to create badly needed trust in these technologies? I think the correlation between trust and the law is complex. And those of you who have done legal sociology at law school, you might remember Max Weber and then the idea that trust in personal trust, interpersonal trust, organic solidarity, as Durkheim, I think, expressed it, was replaced by trust in the law to a certain extent. But it is a very different type, a different quality of trust. And I think we should be careful not to overemphasize the ability of law to generate trust. If I only trust you because I think you will be caught and punished if you hurt me, then I don't really trust you. So we have to be very careful not to rely too much on the law alone, as important as it is. Now, the law is special in a number of ways, different, I think, from other applications of AI. And I want to flag throughout the talk 3 aspects which we try to reflect also in our principles, where I think they are substantially different from what we find, say, in finance or in media. And one of the most important ones is that law is a regulated profession, and that lawyers, especially practicing lawyers, sign up to specific ethical principles that are enforceable, not by the state directly, but by their professional organization. They can get disbarred for unethical behavior. So here we have a situation where the notion that ethics goes beyond the law becomes slightly more problematic because ethics gets teeth in the self-regulation of the professional organizations. And what we think is that these have a particularly important role to play in introducing AI in the justice system. Again, we heard this morning that there will be different certification schemes, for instance, proposed, some self-certification, some third-party certification. And one of the things we think is that the ethical aspects in particular will make particular demands on the professional organizations that we find in all European countries that regulate the legal profession. It is there, they primarily were the addressee of some of our principles. We do think that the stakes are particularly high here. And that again refers back to the question of trust and the role of law in generating trust. All 6 other subgroups, and something we also see in the European Union proposal, of course, is a reliance on the law as a fallback solution. So behave, be ethical, comply with best standards, because if necessary, the law will come in and sanction your behavior. And that means the trust in the secondary rules and regulations is backed up by trust in the legal system. But if the trust in the legal system itself is eroded through the use of AI, then all these other approaches also start to get undermined. So there is a sort of feedback circle here when we are talking about law and ethics for AI. It is fundamental or a precondition for trust and compliant behavior in all of the other fields as well. And because of that, we think that one of the principles that we propose is, again, remember, these are just the drafts, is what we call the principle of transversal impact assessment. The rule of law and the concept of legality go beyond the relation of the AI user and the person affected by the AI. So if we have, say, in finance, an AI making a decision about a credit card application, that is primarily an issue between the bank and the applicant here. In law, I think we should be very careful to reduce the ethical dimension to the relation between a lawyer using the AI and the client, because we can think of situations where the use of these technologies is clearly good for the law firm. It's also clearly good for the client. It's maybe even good for everyone involved in that specific case. And nonetheless, there might be long-term consequences for society that are detrimental. Give you an example. Predicting the outcome of a case might prevent people to invest unnecessarily resources in frivolous litigation. That's a good thing. There is a benefit here. Having a more realistic account of the implication it can have on your resources to sue, and maybe you find a better solution, an arbitrated solution, for instance. That is good for you, it is good for your lawyer, it's good for the justice system, because justice systems, I think, in all throughout Europe are struggling with massive caseload. They are overworked. So reducing this by filtering out problematic cases initially sounds very, very good. But once we probe this more rigorously, we also see that potentially edge cases are now not any longer pursued. And if you look at some of the most important socially beneficial changes we had in the law, they very often came as a surprise to the legal profession, to society, to everyone. In the eve of the Stellar decision in the UK, in Scotland, sorry, if you had asked any lawyer how the case would end, they would have said Stellar will win, because there was at that time a widely held belief that rape within marriage was not a crime, at least not the crime of rape, potentially sexual assault. That was established law. There were lots of precedent cases. There was lots of academic writing. If you had made a survey, that would have been the answer. But in that specific case, the Advocate General was able to make an innovative legal argument that changed 200 years of jurisprudence and introduced the concept of marital rape into Scots law, which I think was long overdue and really, really important. Had the lawyer for the fiscal's office or the legal aid board used an AI to predict the chances of winning that case, they would have been told you don't have a chance, and they might have been deterred from bringing this very important case. So here we see that the ethical impact might go beyond a small identifiable number of individuals in a given case. And for that, we need a different type of thinking about these ethical impacts. And again, we think the law societies are potentially quite well placed for that. That's reflected in principles that we have here, a principle of ultimate responsibility and the principle of collective responsibility, which essentially says using AI as a tool is an exercise of professional judgment. It must never allow a lawyer to wiggle out of obligations they would otherwise have. They are not allowed to say, well, the AI told me so. You as a professional stick out your neck. This is your judgment and you're responsible to it. And that means there's also a collective responsibility here through the professional bodies to ensure appropriate use of these technologies. I'm very quickly mentioning this because some of these questions are not even new. Back in 1998, the UK introduced for the first time a legal basis for fully automated decision making. That's good old-fashioned AI. That's a type of AI I grew up with. It's symbolic manipulation. It's not machine learning. We know exactly what the system is doing in deciding about social security applications. And the hope was it would be faster, it would be cheaper, and would be fairer. And that means if it works, it should work also for the citizen. They have to wait not as long for important payments that they receive. It's good for the taxpayer and society because it's cheaper. And it is also fairer because it might, or that was the hope at the time, reduce individual bias by social security, public servants who are making that decision, social workers who are making that decision. And if you look at the parliamentary debate at the time, I think it was very much alert to the problems that could come up here. Firstly is, do we know the decision is right? Well, good old-fashioned AI, that's relatively easy. But assume it is wrong. How can we contest it? What are the remedies? We should never put an AI in place with assuming everything will be right. We always have to think about what are the remedies? What is your plan to make good if things have gone wrong? The second is the issue of explanation. Even if decisions are correct, legal decisions need to be explained. And that is important for law. It's not enough that decisions are correct. They need to be explainable, and not just to the claimant, not just to the other party, but to wider society. If a judge gives a reason to their decision, they fulfill an important political and social function. They reassert the norms to which we agreed to abide by. They explain the law to the population and make it knowable and with that compliable. So we need a way to communicate to different audiences why specific types of legal decisions have been taken. And then finally, even if we assume that the decision is correct and can be explained in an appropriate way, is it correct, is it appropriate to treat a claimant like this? And that is an important discussion that came up at the time, back in 1996, where some parliamentarians, I think, exactly had the right type of intuition. They were saying there's a problem here that we single out social security law and use this as a sandbox, to be slightly cheeky to the EU regulation proposal, an environment where normal rules do not apply. And who is chosen here as a citizen? Those who are already the most marginalized, the most vulnerable. Maybe it would have been better to trial this out for commercial building permit applications. Or some other field where the citizens are likely to come from an affluent group which are well resourced and can fight for their rights. There might be something inherently wrong, even if the decisions are correct, to treat the most vulnerable in society, the most marginalized, different from everyone else, and in particular, deprive them of the dignity to interact with a human being. Now, there are lots of mights in there. They might find it, the citizens might find it easier to interact here with a machine, not to disclose their poverty to another human. They might find that more dignified. Well, that is an empirical question, and it also alerts us to the fact that parliamentarians won't know that. The citizen who is affected will know it. And one of the principles, which I probably won't have time to mention, is that good and ethical legal AI always involves in every step of the development representatives of those communities that are most affected by it. We can only know how it would feel for a social benefit claimant to be adjudicated by an AI as opposed to by a human if we ask them and if we meaningfully involve them in the design process. Not just later on as a user test study, but from the beginning in the design process. And that is reflected in one of the principles that we also have. Because in that sense, and that's the third sense in which law is special, law is constitutive for our society. It's not just something that we do, it is something that creates our society. And we have in Europe the ideal of democracy under the rule of law, which prevents democracy simply from becoming a mob rule. And we see this under threat in many European and, for the UK, past European countries at the moment. So there's a real danger here that we get an engineered conflict between democracy, or rather popularism, and the rule of law. And it's important not to weaken these institutions in their time of need. And that's why we have to be particularly careful and treat carefully here when we are using machines, because Legal systems are organically grown over time. They incorporate popular, intuitive understandings of the citizenship. They are imbued with symbolic meaning. There's a reason why our judges, here the UK Supreme Court, are wearing these robes, why there is a ceremony to be adhered to, because it conveys a message that is important for everyone. Or the Miller of Sanssouci, the famous story of Frederick the Great, running foul of the law and losing. The Miller saying, even if you are a king, you can't simply boss me around. As long as there are judges in Potsdam, my rights will prevail. And we grow up with these stories. These stories tell us who we are and give us an ideal of our society. And we can't assume that even a perfect AI that replicates human reasoning in a very high level of fidelity can sustain and maintain this type of symbolic significance. Legal systems are grown over time, and ethos of move fast and break things just doesn't fit here. So I think these are the things, the more fundamental consideration that we try to recognize in some of these principles. And I won't have time to go all through with them. The foundational principle for us is respect for the rule of law, because of its really central importance for our society. And we try then to concretize and make operational what respect for the rule of law can mean. One of that is, as I said, law is culturally grown, it is culturally embedded, it carries excess symbolic meaning, and it is shaped by power imbalances. So good legal AI is always sensitive to power relations. You can't do ethics without thinking about power. And most ambitiously, AI in law should always aim to reduce existing power imbalances, give access to the citizenship, to everyone, to justice, make it more affordable, ensuring that those who are weakest find their voice. And that, I think, as I said, was one of the problematic aspects in 1996. There's the principle of public justice. The cornerstone of our understanding of the law is the open and fair trial. And legal technologies that lower these access burdens are generally good and should be promoted. But at the same time, we are facing walled gardens potentially. We're facing new ownership claims over legal data as we move from justice being provided through legal professionals to potentially justice provided by digital publishers. LexisNexis and Westlaw are the biggest investor in legal AI. We must make sure that we do not create property regimes that suddenly create new access barriers to the law and undermine the principle of public justice. Principle of procedural transparency and unfettered participation. Again, what we mean with that is that law is a concern for all citizens. We do not outsource legislation to experts for a reason. We want involvement of parliament, we want involvement of communities, we have processes to involve this participation. So one important aspect of legal design and AI is to ensure that these principles of unfettered participation, giving everyone a voice, are not suddenly replaced through a technological discourse. There should not be a situation where moving from human adjudication to machine adjudication or decision making reduces the ability to participate. So I'm running already out of time, which I had feared. I only was able to mention 4 of our 20 principles, but I think it gives you a flavor of what we tried to achieve. We tried to take the rule of law ideal as our starting point and ask in concrete conditions what it would take for the rule of law to be maintained in an AI environment. And hopefully, as I said, in October, we'll be presenting these results and hopefully they will get some traction. Thank you for your attendance.